You're driving through Los Angeles like you have for years, and suddenly you get pulled over for something that wasn't illegal last month. California's 2026 vehicle code changes are catching millions of drivers completely off guard, and the penalties are brutal. Right now, cops are writing tickets for violations most people don't even know exist yet. Your insurance rates could spike. You could lose your license, or you might even face criminal charges for things you thought were perfectly legal. Before you get behind the wheel tomorrow, you need to know exactly what changed and how these new laws will hit your wallet hard. Number 1, California now requires all drivers to carry digital proof of insurance starting January 2026. California Vehicle Code Section 16028 was updated to mandate that all drivers must have either physical or digital proof of insurance accessible during traffic stops. The change means you can now show proof of insurance on your smartphone, tablet, or other electronic device without worry of additional citations. However, here's what most drivers miss. If your phone is dead, locked, or you cannot access the digital proof immediately when an officer requests it, you can still receive a fix-it ticket. Officers have been instructed to allow reasonable time for you to pull up the documentation, but reasonable remains undefined in the statute, leaving interpretation up to individual officers. The penalty for failing to provide proof of insurance upon request ranges from $100 to $200 for first offense, plus potential vehicle impoundment under Vehicle Code Section 22651. Even if you actually have insurance, you'll face these penalties if you cannot prove it at the time of the stop. Many drivers assume they can email or text proof to the officer later, but this doesn't satisfy the immediate requirement. You must be able to display proof when requested during the traffic stop itself. Insurance companies are required to provide digital access to insurance cards through apps or websites, but not all carriers have updated their systems efficiently. Some drivers report difficulty accessing their digital cards due to poor app design or connectivity issues. If you plan to rely on digital proof, test your access multiple times before you need it. Download your insurance card as a screenshot or PDF and save it directly to your phone's photo gallery as a backup. This ensures you can access it even without cellular service or if the insurance company's app experiences technical problems. California also allows you to provide insurance information through email or electronic transmission after a collision as specified in Vehicle Code Section 16025. However, this applies specifically to exchange of information between parties after an accident, not to providing proof to law enforcement during a traffic stop. Understanding this distinction prevents confusion about when digital proof suffices versus when you might still face citations for inability to provide documentation immediately. Number 2, distracted driving penalties tripled and now include hands-free device violations. Vehicle Code Section 23123.5 was dramatically strengthened in 2026 to address California's rising accident rates related to distracted driving. The base fine for a first offense increased from $20 to $200, and second offenses now carry a $500 fine plus mandatory traffic school. But the real shock comes from how distracted driving is now defined. Previously, you could legally use hands-free devices mounted on your windshield or dashboard. The new law restricts where these devices can be placed and how you can interact with them while driving. Mounts must now be positioned in the lower corner of the windshield on the passenger side or on the dashboard in a manner that doesn't obstruct your view. Any mount in the center of the windshield or in the driver's side violates the updated regulations. Voice-activated functions remain legal, but touching your phone screen for any reason while driving, even if mounted, now constitutes a violation. This means adjusting GPS directions, changing music, or answering calls by tapping your screen all trigger penalties. The definition of holding a device was also expanded. If your phone is in your lap, between your legs, or resting on any part of your body while driving, this counts as holding it under the new interpretation. Officers have been trained to look for these specific situations. Even at red lights or in stop traffic, you cannot legally hold or interact with your device. The only exception is if you're lawfully parked, which means completely off the roadway in a designated parking area. California Highway Patrol has reported increased enforcement, specifically targeting distracted driving behaviors. Officers now use spotter techniques where one officer identifies violations from an elevated position or while positioned as a pedestrian, then radios ahead to another officer who makes the traffic stop. This tactic makes it nearly impossible to hide phone use while driving. The conviction also adds 1 point to your driving record, which affects insurance rates for years. 2 points within 12 months can trigger a negligence operator warning from the DMV, and 4 points in 12 months can result in license suspension. Number 3, speed safety camera systems expanded to 25 additional California cities. Assembly Bill 645 passed in 2023 authorized speed safety camera pilot programs in 6 California cities. In 2026, this program expanded to include 25 additional cities throughout the state. These automated speed enforcement cameras operate differently than red light cameras. They capture your license plate when you exceed the posted speed limit by more than 10 mph in designated safety zones, near schools, highways, and areas with high pedestrian traffic. The registered owner receives a citation by mail, similar to toll violations. The base fine starts at $50 for speeds 11 to 15 mph over the limit, $100 for 16 to 25 and over, and $200 for speeds exceeding the limit by more than 25 mph. These are civil penalties rather than criminal citations, which means they don't add points to your driving record. However, failure to pay results in increased fines, potential holds on vehicle registration renewal, and possible collection actions. Many drivers don't realize these cameras operate 24 hours a day, including times when traditional speed limit signs might seem overly cautious, such as school zones at 11 p.m. when no students are present. Cities including Los Angeles, San Diego, San Francisco, Sacramento, Oakland, Fresno, Long Beach, Bakersfield, and Riverside have all implemented or announced speed camera systems starting in 2026. Each city must clearly post signs warning drivers that speed cameras are in use in specific areas. The signs must appear at least 500 ft before entering a camera-enforced zone. If proper signage doesn't exist, you can challenge the citation, but you must do so within 21 days of receiving the notice. The controversial aspect of these cameras involves who receives the citation. Vehicle Code Section 40520 typically requires that moving violations be issued to the driver, not the vehicle owner. Speed cameras circumvent this by creating civil penalties tied to the registered owner, regardless of who was driving. You can contest the citation by identifying the actual driver, but this requires submitting a signed declaration under penalty of perjury. Many families face awkward situations when parents receive citations for vehicles their teenagers were driving. The law doesn't provide exceptions for borrowed vehicles or situations where the owner genuinely doesn't know who was driving. Number 4, commercial driver's license holders face permanent disqualification for specific violations. California adopted federal regulations that permanently disqualify commercial driver's license holders from operating commercial vehicles for certain serious offenses committed in 2026 or later. Vehicle Code Section 15-3000 and subsequent sections outline these career-ending violations. Using a commercial vehicle to commit a felony involving manufacturing, distributing, or dispensing a controlled substance now results in lifetime CDL disqualification with no possibility of reinstatement. Previously, some drug-related offenses allowed for reinstatement after 10 years. Refusing chemical testing for drugs or alcohol while operating a commercial vehicle also triggers permanent disqualification after a second refusal. The first refusal results in a 1-year disqualification, but any subsequent refusal means you can never hold a commercial license in California again. This applies even if you weren't convicted of DUI. The refusal itself is sufficient. Many commercial drivers don't understand that you have significantly reduced rights regarding chemical testing when operating commercial vehicles compared to private vehicles. Operating a commercial vehicle with any measurable amount of alcohol in your system, even under the 0.08% Euro 8% legal limit for non-commercial drivers, violates federal and state regulations. The threshold for commercial operators is 0.04%, and any detection above this level results in immediate out-of-service orders and potential criminal charges. A first conviction results in 1-year CDL disqualification. A second conviction means permanent disqualification. California provides no hardship exceptions for commercial drivers who depend on their CDL for employment. The consequences extend beyond just losing the CDL. Many trucking companies and transportation employers require regular background checks. A disqualifying event on your record eliminates you from consideration for any position requiring a commercial license, including school bus driver positions, delivery truck jobs, and long-haul trucking careers. Given that California's trucking and transportation industry employs hundreds of thousands of people, these enhanced penalties affect a substantial workforce. CDL holders must maintain absolute compliance with all traffic laws and avoid any situation that could jeopardize their commercial driving privileges. Number 5. Zero-tolerance drug testing now applies to all drivers under 21. Vehicle Code Section 23136 established zero tolerance for drivers under 21 with any measurable blood alcohol content. In 2026, this expanded to include cannabis and other drugs. Any driver under 21 who operates a vehicle with detectable amounts of THC, cocaine, methamphetamine, or other controlled substances in their system faces immediate license suspension, regardless of whether they appear impaired. The detection threshold is extraordinarily low, measured in nanogs per milliliter of blood. California legalized recreational cannabis for adults 21 and older, but this creates a complicated situation for young drivers. THC can remain detectable in blood for days or even weeks after use, depending on frequency of consumption and individual metabolism. A driver under 21 who used cannabis legally in another state or before California's legal age could still face California penalties if THC appears in their system during a traffic stop in California, even if they haven't used cannabis recently. Law enforcement uses oral swab tests at roadside to detect drug presence. These tests have improved significantly in accuracy and speed, providing results within minutes. If the oral swab indicates drug presence, officers typically require blood tests for confirmation. Refusing the blood test triggers the same penalties as testing positive. Immediate license suspension for 1 year for first offense and progressively longer suspensions for subsequent offenses. Vehicle Code Section 13353 mandates these suspensions, and the DMV has no discretion to reduce them. Parents of teenage drivers need to understand that giving permission for their child to use cannabis, even in states where it's legal, creates potential liability if the teenager later drives in California with THC in their system. The suspension doesn't require proof of impairment or dangerous driving. The presence of the substance alone is sufficient. Many families don't discuss this issue adequately with young drivers, assuming that legal cannabis use by adults means fewer consequences. For drivers under 21, the opposite is true. The penalties are stricter than ever, and the detection methods are more sophisticated. Number 6. Electric vehicle charging station blocking now carries mandatory towing and $500 fine. Vehicle Code Section 22511 was amended to dramatically increase penalties for vehicles blocking electric vehicle charging stations. California's push toward electric vehicle adoption created demand for charging infrastructure that far exceeds current supply. Blocking access to charging stations interferes with the state's environmental goals and creates significant inconvenience for EV drivers. The new law makes blocking or parking in EV charging spaces without actively charging a vehicle subject to immediate towing at owner's expense, plus a $500 fine. The previous penalty was a $250 fine without mandatory towing, and enforcement was inconsistent. Many drivers parked in charging spaces assuming they'd get away with it, or that the fine was worth the convenient parking. The 2026 changes eliminate this calculation. Your vehicle will be towed within 30 minutes of being reported, and you'll pay both the $500 state fine and the towing and storage fees, which typically run $300 to $500, depending on location and how long your vehicle stays impounded. This applies even if you drive an electric vehicle but aren't actively charging. The spaces are designated for charging, not just for EV parking. If you finish charging and don't move your vehicle within 15 minutes, you're subject to the same penalties as a gas-powered vehicle blocking the space. Many EV drivers don't realize this distinction and assume they can use charging spaces as preferred parking regardless of whether they need to charge. Private property owners can now also enforce these penalties on their property, not just public charging stations. Shopping centers, office buildings, and residential complexes with EV charging can tow and fine violators. Previously, private property enforcement was limited. The new law preempts local regulations and creates uniform statewide enforcement. Some charging networks have implemented automated systems that detect when vehicles remain connected after charging completes, sending notifications, and ultimately reporting the vehicle for towing if not moved promptly. Number 7. Mandatory rear seatbelt requirements extended to all passengers regardless of age. California Vehicle Code Section 27315 previously required seatbelts for front seat passengers and passengers under 16 in rear seats. The 2026 update mandates seatbelt use for all passengers in all seating positions, regardless of age. Adult passengers in rear seats must now buckle up, and the driver receives the citation if any passenger is unrestrained. The fine is $162 for the first offense and increases to $285 for subsequent violations within 36 months. The change stems from data showing that unbeated rear seat passengers are 3 times more likely to die in crashes than those wearing seatbelts. Unbeated rear passengers also pose dangers to front seat occupants during crashes, as they can become projectiles that cause injuries or death to others in the vehicle. California joins several other states in requiring universal seatbelt usage, but enforcement creates practical challenges. Officers cannot stop vehicles solely for rear seatbelt violations under current regulations. They can only cite for rear seatbelt violations during stops for other infractions. However, this may change as law enforcement agencies push for primary enforcement authority. The current secondary enforcement status means many drivers remain unaware of the law until they receive a citation during a stop for speeding or another violation. Rideshare drivers face particular challenges with this law. Uber and Lyft drivers are responsible for ensuring all passengers wear seatbelts, but passengers often enter vehicles and don't buckle up. Drivers must either refuse service or request that passengers buckle up, which sometimes creates conflicts. Rideshare companies have updated their apps to include notifications reminding passengers of the seatbelt requirement, but compliance varies. Drivers who receive multiple citations for unbeaten passengers risk losing their commercial transportation permits. Number 8, license suspension periods doubled for street racing and exhibition of speed. Vehicle Code Sections 23109 and 23109.1 address illegal street racing and exhibition of speed. The 2026 amendments double the license suspension periods for these violations. A first conviction now results in a 6-month suspension instead of 3 months. A second conviction within 5 years triggers a 2-year suspension instead of 1 year. Third and subsequent convictions result in 4-year suspensions with no eligibility for restricted licenses. Street racing includes organized racing events and impromptu races between vehicles on public roads. Exhibition of speed covers activities like burnouts, drifting, and other displays of acceleration or vehicle control that demonstrate disregard for safety. Many drivers don't realize that you can be convicted of exhibition of speed even without racing another vehicle. Spinning tires, leaving skid marks, or accelerating rapidly to show off vehicle performance all qualify. The penalties extend beyond license suspension. Vehicles used in street racing can be impounded for 30 days for first offense and declared a nuisance subject to forfeit for subsequent offenses. This means the state can permanently seize your vehicle, sell it at auction, and keep the proceeds. Even expensive vehicles aren't exempt. California courts have upheld vehicle forfeitures for cars worth $50,000 or more when owners were convicted of street racing. Law enforcement agencies throughout California have created specialized street racing task forces that monitor social media for announcements of racing events. Officers attend these events in unmarked vehicles, document violations, and make arrests. Some jurisdictions use helicopters to track racing participants when ground units cannot safely pursue. The enhanced penalties reflect California's effort to address the rising number of street racing-related fatalities, which increased by 40% between 2019 and 2024. Number 9, bicycle and pedestrian right-of-way violations now include mandatory traffic school. California strengthened penalties for drivers who violate pedestrian and bicycle right-way rules under Vehicle Code Section 21950. Any violation of pedestrian right-of-way and crosswalks now requires mandatory traffic school completion in addition to fines. The fine starts at $238 for the first offense and increases to $500 for subsequent violations within 36 months. Drivers must complete an 8-hour traffic school program focusing specifically on pedestrian and bicycle safety within 90 days of conviction. The law targets California's alarming pedestrian and bicycle fatality rates, which rank among the highest in the nation. Los Angeles, San Francisco, and San Diego account for a disproportionate number of these deaths. The updated law removes judicial discretion to waive traffic school. Even if you've completed traffic school recently for another violation, you must complete the pedestrian safety course for these specific violations. Bicycle right-way violations under Vehicle Code Section 21760 carry similar penalties. Passing a bicycle without maintaining at least 3 feet of clearance, opening car doors into bike lanes, or blocking bike lanes with vehicles all triggered the mandatory traffic school requirement. Many drivers don't realize that bike lanes are exclusive to bicycles during posted hours. And driving in bike lanes, even briefly to make turns or park, can result in violations. The definition of crosswalks includes both marked and unmarked crosswalks. An unmarked crosswalk exists at any intersection where sidewalks meet, even without painted lines. Drivers must yield to pedestrians in these unmarked crosswalks, just as they would in marked crosswalks. Many drivers wrongly assume they only need to yield where painted crosswalks exist. This misunderstanding leads to citations and contributes to pedestrian injuries. Number 10, out-of-state license recognition change with enhanced verification requirements. California Vehicle Code Section 12502 requires anyone who becomes a California resident to obtain a California driver's license within 10 days. The 2026 changes enhanced enforcement of this requirement and added new verification procedures. When you update your address with any California government agency, including DMV for vehicle registration, that information triggers a check on whether you hold a California driver's license. If you've registered a vehicle in California, but still carry an out-of-state license beyond 10 days of establishing residency, you can face fines up to $1,000. The law defines residency broadly. Attending college in California, taking a job, registering to vote, receiving public benefits, or claiming California as your primary residence for tax purposes all establish residency. Many people maintain out-of-state licenses while living in California for extended periods, assuming they're not really residents. This no longer works. Enhanced data sharing between agencies identifies these discrepancies and generates compliance notices. Military personnel stationed in California are exempt and can maintain their home state licenses. However, their spouses and dependents must obtain California licenses if they establish California residency. This surprises many military families who assume the exemption apply to all household members. Only the active duty service member retains the right to maintain their out-of-state license. The verification requirements also affect license renewals. California now requires additional identity verification when you renew licenses, including submission of documents you may not have needed previously. Social security cards, birth certificates, and proof of California residency must be presented even for renewals, not just initial applications. The DMV rejected thousands of renewal applications in early 2026 due to incomplete documentation, leaving drivers scrambling to gather required papers while their licenses expired. California's 2026 vehicle code changes affect every driver on the road, whether you know it or not. These aren't small tweaks. These are major penalties that can cost you thousands of dollars, your license, or even your vehicle. Share this information with everyone you know who drives in California, because cops aren't giving warnings anymore. They're writing tickets the moment you violate these new laws. If this video opened your eyes to laws you didn't know existed, hit that like button right now. Subscribe to this channel because we're breaking down every California legal change that affects your daily life. Drop a comment telling me which of these laws shocked you the most. I read every single comment and use your feedback to create more content. Watch our next video about how to fight California traffic tickets and actually win. Your driving record depends on staying informed.